families, creating a lifetime of memories. Sadly, some families are denied these important moments due to the sad practice of alienation. These are families divided.
Hello, everyone, and welcome to another edition of Families Divided TV. If you've never clicked on the subscribe button and subscribed to our network, we would really appreciate it if you would do that. We have many videos here that will help you, over 200, and we're adding more all the time. If you want to get those notifications as soon as we add them, click on the bell and you'll know exactly when we add them. We have some of the top experts in the world, and we're very grateful that we have them who spend so much time to give you this information. So it's great for you who are going through alienation as an alienated family member, and it's also great for those of you who work in the field of alienation as a professional. So please share these videos as you have been doing. We appreciate it. Also, I want to speak to you about our conference coming up. Today, we're going to hear from Dr. William Burnett, who will be speaking at our conference. We're very excited about that. Our conference is in October. It's an international virtual conference, and it's entitled Alienation, the Truth Regarding the Trauma and the Abuse. There is so much false information that's going around out there, and this really is going to help. You're going to hear the truth about the forensics and many things on the trauma and the abuse of alienation. And I really hope you'll join us. This is absolutely, by far, the best conference we have ever had. We're going to start on Friday night. We're going through Sunday night. We literally are going to be going into the night. We've planned so many different activities for you to be fun, things that'll be fun, things that'll be knowledgeable, supportive. So I do hope you'll go ahead and register and join us. Many already have, and we're grateful for that. And we're really excited about it and looking forward to it. So we're going to come back with all of this information for you in just a moment. But I wanted to just tell you that Dean Tong is going to be speaking today about the ins and outs on the child interviews. Most cases of alleged child sexual abuse, and to a lesser degree, child physical abuse, are decided by the forensic interviews of the reporting victims. Listen up today and take notes. Dean Tong is going to give you some incredible information, and we're going to bring this to you right after these messages.
Divorce and co-parenting are a major life interruption for families, especially the kids, but also for parents and grandparents. And it's even worse in blame-filled, high-conflict cases. When parents engage in alienation by turning the kids against the other parent or grandparents, kids suffer. They're denied the opportunity to build the 4 big skills necessary for future resilience. New Ways for Families online class can help. Parents learn to use our popular BIF and EAR skills to calm the conflict and stop the hostile emails and texts. And we even have a class for kids and parents to learn together. Research shows a 75% improvement in joint parental decision-making after this course is taken, plus overall improvements for kids' well-being. Don't wait to make this affordable investment in your children's future and improve your well-being too. Start learning new ways for your family today at conflictplaybook.com.
Sadly, too many know the pain and trauma associated with parental and grandparent alienation. Family Access, Fighting for Children's Rights, will present an important international virtual conference on October the 13th through the 15th, 2023. Alienation, the Truth Regarding the Trauma and Abuse will feature world-renowned experts in the field of alienation. You'll join conference event coordinator Elaine Cobb and moderator Megan Hunter as they introduce you to keynote speaker Dr. Edward Crook. Plus, You'll hear important presentations from Dr. Joshua Coleman, Lisa Rothfuss, Dr. Mary Alvarez, Chris Smith, Bill Eddy, Dr. Sue Kornbluth, Dr. William Burnett, Melanie Gill, and Megan Hunter. Join the many attendees already securing their spot for the conference. Alienation: The Truth Regarding the Trauma and Abuse. Visit familyaccess.info for all the details. This special conference is being hosted by Family Access Fighting for Children's Rights, by Still Partners Foundation, and by PA-ISCA. Parental alienation is child abuse.
I'm Dean Tong. I'm a nationally certified and registered child forensic interviewer talking to you today on the ins and outs of child forensic interviews. Now, if you've been accused of child physical abuse or child sexual abuse, this is going to be an important little seminar for you, because your child most likely will be taken to the Child Advocacy Center to conduct a forensic interview. That should be captured on DVD, as that's required under the policy. Most of these cases are child victim hearsay. He said, she said, what a child said. Only 5% of the same contain physical, medical, forensic proof. So most of these cases are hearsay. This is the out-of-court statement made by a child. It is the exception to the hearsay rule, which means it's coming into evidence. There are factors that govern the child's credibility. Those factors are spontaneity, reliability, and trustworthiness. So if you're not spontaneous, if a child's statements are not spontaneous, the child may have been coached, may have been indoctrinated, may have been conditioned, may have been bribed or rewarded to say things that didn't happen, but the child says they did happen. Children are very suggestible. If they can talk about the Tooth Fairy, Santa Claus, Peter Pan, and Easter Bunny, they could talk about how Daddy touched my pee-pee. This has been well documented in studies by Dr. Stephen Ceci, Dr. Maggie Bruck, in their 1993 seminal study, The Suggestibility of the Child Witness, a Historical Review and Synthesis, and in their 1995 best-selling book, Jeopardy in the Courtroom. I want to thank Elaine Cobb for having me today. Their website for you folks, again, is familyaccessfightingforchildren'srights.com. That's familyaccessfightingforchildren'srights.com. The child forensic interview is a very important topic in these cases. CPS gets involved. They will transport the child, your child, perhaps over your objection, to the Child Advocacy Center to conduct that interview. For a little child, 3 to 4 to 5 years old, that may last 20 to 30 minutes. For an older child in their teens, it could last an hour or longer. I have looked at hundreds of children's interviews over the past quarter century, back to the 90s. Some are very good, some are very bad. Most of them are in between. To give you a little history on the child forensic interview process, you want to look at the website nationalcac.org. Nationalcac.org is out of Huntsville, Alabama. This is basically where this all got started in the 70s or 80s. They used the Huntsville or cognitive methodology. That is a semi-structured methodology. What does that mean? That means the interviewer is allowed to use leading, suggestive, direct, reinforced, repeated questions, forced choice questions, which mandate giving the child a choice to choose, and also questions involving negative stereotype induction. Negative stereotype induction means the interviewer, rather, is basically vilifying or pointing the finger at the accused with no alternate hypothesis, no other theory on how the child is saying or why the child is saying what she or he is saying. So to go back to the history again, going back to the 80s, this process started and the methodologies basically developed over time. So in 1990, we saw APSAC, that's APSAC.org is their website. That method developed in 1990. That's the American Professional Society on the Use of Children. That is a professional organization. We also saw Corner House. Corner House was developed in Minnesota. It became refined in 1998 by the American Prosecutors Research Institute, APRI, in Northern Virginia. This method, Corner House, is also called Finding Words. It's also called Child First. It's also called RATAC. That's RATAC. So RATAC, that acronym stands for the following. The interviewer builds a rapport with the child. The interviewer goes over the anatomical identification of body parts with the child. The interviewer goes over touch inquiry with the child. That's good touch, bad touch, and secret touch. Then the second A in that acronym stands for the index abuse allegations or abuse allegations. And then C stands for closure. So the RATAC has a structured format to it, but it's not a structured methodology. None of the methodologies which I have just mentioned, and I haven't even included the stepwise methodology authored by Dr. John Newell out of British Columbia, Canada, which actually promotes a incremental interviewing technique of children over time. In other words, multiple interviews of the child victim. None of these are fully structured methods. The only fully structured method is the NICHD. The NICHD was first introduced in America by my retired colleague and associate, Dr. Phil Esplin. Dr. Esplin worked with Dr. Michael Lamb and other psychologists to develop this National Institute for Child Health and Human Development methodology for interviewing children allegedly abused out of Bethesda, Maryland. This method was first published in 2000. It was replicated in 2007. And Dr. Lamb and Dr. Esplin co-authored a book published by Wiley titled Tell Me What Happened in 2008. That book was republished in 2018. In 2009, there was developed another method that is used in my state of Florida, partially used also in Idaho, called, in other states also called RADAR. RADAR is recognizing abuse disclosures and responding. Now, there are experts out there who promote RADAR as a quasi-structured methodology or a modified NICHD, such as Dr. Mark Everson. Dr. Mark Everson's writings on RADAR have been published in APSAC Advisor. Ironically, Dr. Everson, no disrespect to him, was the original, one of the original co-authors of the anatomical doll methodology for interviewing children and treating children in therapy back in 1990 when he worked with Dr. Barbara Boat at Cincinnati Children's Hospital in Ohio. Dr. Everson, I believe, is now in North Carolina. Dr. Everson actually had to go back to the drawing board on his anatomical doll studies because the children interviewed as test subjects in that study played more angrily and sexually with the dolls than not so. I have a chapter in my book, Elusive Innocence, chapter 10, titled The Dolls. And of course, we found a lot of problems with the use of these dolls. I'm not going to elaborate on that in this talk. Now, to get back to the RADAR study, on the child forensic interview RADAR study, that is a semi-structured method, just like APSAC, just like RATAC, just like the National Children's Alliance, which is widely used in America, the NCA method, okay, which means they are allowed to use some suggestive, leading, direct, repeated questions in the interview, and they do. And I get some where they use a lot of them. And, you know, these types of questions can contaminate, adulterate, and taint a child's information. So you don't want to put words or thoughts or ideas into the child's mind. You want the child to elicit a free recall, free narrative, free account response to your question as an interviewer. Can you tell me what happened? Tell me about that. Can you tell me more about that? So this taps into the implicit or unconscious memory of the child, not the explicit or conscious memory of the child. This is the side of the brain that lends itself to contamination and taint and adulteration. If you look at the law that guides the judge and jury in these cases on the credibility of children, it is governed by factors known as spontaneity, reliability, and trustworthiness. To be clear, you're only going to attain a free recall, unconscious memory from the child if you're using an open-ended question. Can you tell me what happened? Okay, if you put words or thoughts or ideas in the child's mind in your question, such as, did daddy touch your pee-pee? That is leading, that is suggestive, that is a direct question, calling for a yes/no response. You're basically causing the child to possibly contaminate his or her disclosure there. Okay, so the radar method, and the reason I titled this talk, The Ins and Outs of Child Forensic Interviews, the radar method is supposed to start off with open-ended questions where the interviewer goes in with those same questions, and then later on in the interview goes out with direct questions. Well, I'm just not a supporter from the research standpoint of using direct questions, of using any type of question that can contaminate or taint or adulterate the child's information, especially when so much is riding on the child's disclosure, whether something happened to that child. It's very possible we can get a false negative from a child who's not disclosing or who is very shy in disclosing. And then, of course, you want the interviewer to screen that child to see if the alleged perpetrator told the child to keep this a yucky secret, keep this a secret, don't tell anybody, or I'm going to hurt your mom, I'm going to hurt your grandma, your grandpa, or whatever. So I see this occasionally, because obviously my practice deals with child sex abuse mainly, also some child physical abuse cases. But while I specialize in unfounded, unsubstantiated, and false cases, I do see some genuine cases. And obviously, I'm not a hired gun, so I'm looking for the truth behind the scenes coming from the reports from the child to the interviewer. So it's all about the relationship between the interviewer, the interviewee, how many people the child or children have talked to, which could cause possibly memory source contamination to the child, whether the accuser behind the child has a motive, a method, a means, or opportunity to wield that child as a pawn, weapon, or tool in a high conflict divorce or custody battle to gain equity at law in court, or there's a trigger involved, perhaps a book that mommy was well-meaning, well-intentioned, but perhaps misguided, not understanding that the information in that book, It's My Body, or The Devil Takes the Youngest, or The Courage to Heal, might distort the memories of that child, might cause the production of schemas, which are enzymes or proteins that can alter or modify the child's memories. So it is absolutely essential we try to elicit from the child interviewee accurate information, spontaneous, reliable, and trustworthy information. We have to glean who all the child talked to, whether the child talked to the teacher, the guidance counselor, the principal, Mary Jane, a friend at school, Mrs. Jones, a therapist, Miss Smith, the child protective investigator, who may have done a minimal facts interview with that child. We have to know how many people and who the child talked to before they got to the child forensic interview. The child forensic interview is supposed to simulate the outcry or disclosure from the child, whoever the child reported that outcry or disclosure to, whether it was mom, grandmom, a teacher at school, whoever the report came in to the government from and by could be a neighbor, CPS and or the police, we have to understand that this is a very sensitive process, the way this happens, and yet there's only a certain number of days that usually elapse between the child's outcry and the child going for the formal forensic interview. During that elapsed time, could be 2, 3, 5 days a week or a couple of weeks, the child could have talked to 4 or 5 people to basically cause the production of these schemas, which can, from triggers, alter or modify the child's memories and cause misinformation. So I see several false positives in my cases. In other words, children who do disclose during forensic interviews, and then I wind up having to go to court against the child forensic interviewer, against CPS, against the state, against opposing counsel for an opposite litigant against my client, and to basically glean, exactly how that interviewer interviewed the child, whether that interviewer conducted what's called source monitoring. Source monitoring is a very important process here, where the interviewer is exploring alternative hypotheses, basically challenging the child's memory. So if the interviewer uses verbs like touch, nouns like pee or butt before the child does, you are basically stating alleged information for the child. Shouldn't be doing that. Okay, the child has to make the first response. That response should come from the child's autobiographical, reconstructive, free recall memory, not the child's reproductive memory. Now, one of the methodologies I mentioned already, RATAC, also known as Child First, also known as Finding Words or Corner House, which originated from the state of Minnesota, picked up by the state of Virginia, and it is used widely across America. That method and the National Children's Alliance method, probably the 2 most widely used methods. The method that I support wholeheartedly in these cases, the NICHD method, is only used in about 7 jurisdictions. And it's obvious because it's harder for an interviewer to extract an outcry from a child when you're asking only open-ended questions, free recall questions. So there was a case I was involved in 2015, and the case was the state of Kansas versus Justin Flores. And this case was out of Wichita, Kansas. It was a criminal case. And I, along with a psychologist, basically worked with the attorney to have the attorney file a brief to challenge the reliability and validity of the RATAC Finding Words method. This triggered the judge to order what's called a Dober Hearing. That's D-A-U-B-E-R-T. Dober is the science that controls the case law for most states in America on expert testimony and scientific theories. There are a few states that still adhere to the Frye, F-R-Y-E case law. But Dober, was present in Kansas then. I'm sure it still is now. I believe it is, in fact, because I have a civil case I'm working on in Kansas. And so what this requires is that the scientific theory has to be tested. It has to have a known error rate. It has to be peer reviewed and published and accepted by the general scientific community. So the psychologist and I did the research, and we didn't find that the Finding Words method had been empirically tested, and it had been empirically replicated. And with the attorney's help, of course, we challenged the DCF, if you will, and the state of Kansas in their moving forward with their child forensic interviewer and sex crime detective, who were, of course, promoting the use of this Finding Words interview of this child who was the alleged victim in this criminal case that I was working on. Well, we didn't have just one Dober hearing, we had 2. The judge ordered a second Dober hearing because he wasn't totally sure on the first, so we had a second, and we won that. The judge basically ruled that the state of Kansas was not allowed to present expert testimony or even fact witness testimony from a child forensic interviewer or a sex crime detective in the case of Kansas versus Justin Flores, because they used a flawed child forensic interview methodology. And so I have this case on my hard drive, decision by this judge. And for those of you who may need a copy of that case, just email me, Dean Tong, DEANTONG at AOL.com. I'd be glad to send that to you in a PDF. And the reality is, if you're not in Kansas, I believe, and I'm not a lawyer, but I believe this would be a persuasive case law, but not binding case law. Okay. So you want to try to have your attorney and your attorney's paralegal dig up case law from your state in the case that you're involved in that is binding case law. Binding case law would be, a criminal case such as in my state of Florida, State versus Townsend, TOWNSEND, is a 1994 decision from our Supreme Court of Florida, which dictated the factors called the Townsend factors on what a judge and or jury must decide in a case as to the credibility of a child in relation to the child's forensic interview, going to those factors I mentioned: spontaneity, reliability, and trustworthiness. Okay, so if the child's outcry was not made spontaneously, it was not made contemporaneously, it was coached, child was instructed, child was indoctrinated, child was conditioned, child was brainwashed, child was bribed or rewarded to say the things the child said, then obviously the child's information could be tainted, could be adulterated, could be contaminated. Therefore, the child's not credible. And that's basically the nuts and bolts of most of my cases. So very important. It's a Rule 704 issue. The ultimate issue at bar is decided by the trier and finder of fact, which is the judge and or jury, whether it's a civil or criminal case. And it's about credibility, the child's credibility versus the accused adult's credibility. Now, for those of you who think that I only support men falsely accused or fathers falsely accused of incest or intrafamilial child sexual assault, think again. I get many mothers who query me, some who hire me because they've been falsely accused of coaching. They've been falsely accused of saying that basically the father has, committed sexual assault upon the child, and it never happened. It's not what you know. It's not what you think you know. It's what you can prove in court. So in a civil case, that would be by a preponderance of evidence, 51%. I had a huge case down here 4 years ago in Florida, in the Daytona Beach area, where a mother was falsely accused of coaching her child to say that daddy committed anal sodomy, and it was in court for a long time. There were many fact witnesses, there were many expert witnesses, and the judge ruled on our side that the CPS did not prove their petition by clear and convincing evidence to terminate my client's rights. My client was the mother, not the father. Okay, so most dads will be accused, fathers will be accused of child sexual assault. Usually it's inappropriate touching, lewd and lascivious type behavior, even sexual battery behavior, which of course is alleged penetration of any of the child's orifices. But it's the mom who will be falsely accused of coaching. Could be grandma, okay, if grandma has been around the child. So very important, because the child will be taken in any one of these situations to the Child Advocacy Center to conduct that forensic interview. I am actually certified and registered as a child forensic interviewer. The main website for this that controls and trains these interviewers across America is nationalcac.org. That's nationalcac.org out of Huntsville, Alabama. And they offer a 1-week training seminar for prospective interviewers who want to work for the government to interview children allegedly abused. So for those of you, who have who watched NCIS, CSI, Law and Order, in these cases, in my cases, child sexual assault allegations in custody battles, in divorces or not, where parental alienation may be present or not, you're not going to see medical proof for the most part. Only 5%, 1 in 20, is going to have medical abnormalities, forensic medical proof, where it's a slam dunk against the accused. So, this is all going to be a credibility shootout between the child interviewee and the accused adult, which is usually the man, because it's usually the man accused in child sexual assault situations and cases. I am going to end my talk here today, but I hope I have enlightened you to the world of child forensic interviews. The last thing I do want to say, for those attorneys out there or parents out there who want to get a second opinion because a child did implicate you in a bad private part touch during the CAC against you, that's not going to happen. So, you'll have to file a motion to compel the court to order the child to be interviewed by your expert. I can tell you right now it's going to be denied because the child is the crime scene and you don't get to contaminate the crime scene. You don't get to have access to the crime scene, which is ironic because, of course, the government interviewer might have already contaminated the child with leading, suggestive, direct, repeated, forced choice, negative stereotype induction question. With that said, though, chances are you'll not get access to the kid. The state or the CPS attorney or opposing counsel will file a motion for protective order, and that will be granted. So you won't get access to the child. All you'll be able to do is analyze and review and critique the child forensic interview that was conducted by the government at the Child Advocacy Center. I want to thank Elaine Cobb for having me today to present this short seminar to you. And I look forward to talking to you people again in the future. Thank you.
Hello, I'm Dr. William Burnett. I'm a child psychiatrist and forensic psychiatrist in Nashville, Tennessee. I'm looking forward to the virtual international conference that will occur in October 2023. As you know, this conference is created by the organization Family Access, Fighting for Children's Rights. This conference has an interesting title, Alienation, the Truth Regarding the Trauma and Abuse. My own presentation is also somewhat provocative. It's called Truth or Dare, Strategies for Addressing the Epidemic of Parental Alienation Misinformation. One of the unusual aspects of parental alienation theory and practice is the huge amount of misinformation and outright false information that has been published regarding this topic. Over several years, I have documented parental alienation misinformation that was found in peer-reviewed journals, presentations at conferences for mental health and legal professionals, in books edited by psychologists and attorneys, in official statements by professional organizations, and even misinformation in a resolution before the United States Congress. It is impossible to spread the truth about alienation without identifying and counteracting the false and misleading information that is so widespread. In my presentation for the Family Access Conference, I will tell you about several specific examples of misinformation and also our attempts to challenge and correct these false statements. Most of these attempts to set the record straight regarding alienation have been successful. A few have not been successful, and perhaps we can learn something from both outcomes. I'm hoping that the listeners of my presentation at the conference will think about ways they can identify and fight the epidemic of parental alienation misinformation. I hope to see you then. Thank you for your interest in this important topic.
Next week on Families Divided TV, Dr. Chip Chimera discusses with us the importance of a coherent narrative in the process of healing.